Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to be talking about how you need to be very cautious with respect to the advice and suggestions that you might receive from your former boss with respect to your termination and severance pay package. And this also goes with respect to what their lawyer might be representing to yourself. Because both your former boss and their lawyer have an interest in protecting one party and one party alone, and that's your former employer, not yourself. So they're going to take the most advantageous and may well technically be legally correct approach when they provide you with information. However, that information, that advice might not necessarily be the best for yourself. And why is that the case? Well, we look at one simple example. And that is the suggestion that often comes forth to simply go and talk to an employment standards officer, talk to a government official as to what the scenario is, what your rights are with respect to a particular situation. And there are a number of key considerations you have to understand with this particular situation. And first and foremost is the fact that when you speak to an employment standards officer, and then you move on to go the role of employment standards administration to resolve your situations, you are in effect shutting yourself down from taking court action with a lawyer. And there are differences between the two systems. One system is an administrative system with clear limitations and constraints. It's supposed to be designed to be easy, efficient, but also having very strict limitations. And it also follows only matters of statute in the limited capacity that they're able to be followed in. So you can't start approaching aspects of common law within the framework of an employment standards tribunal. That is not for the officer to deal with, and that is cut out. Also, there are limitations with respect to the amount of time that they can look at. And there are timing issues that are very specific to employment standards tribunals that are not necessarily constraining upon a court action that you might take on with a lawyer. Nevertheless, from the perspective of the employer, it's often advantageous for the employee to go down that route because it very much limits the process. And on top of that, it tries to limit the employee from dealing with a lawyer, because instead they have the feeling, the belief that the employment standards officer is working with them and working their best interests. And they might well be trying to do their best at it. But there's another aspect on this. And this is the fact that when you go to an employment standards officer and you start talking to them, they have a very strict and regimented approach to doing things. And it is not necessarily that they're out there trying to challenge the law, trying to find the utmost, and going beyond what seems to be on its face what the statute is saying. They are not necessarily lawyers. Yes, the matter goes before a judge. At times, later possibly on appeal. Sometimes it never gets to the judge. But it does not mean that they have legal training. In the absence of legal training, they often refer to manuals, they refer to interpretations, and they don't necessarily go in and start to tackle stuff like a lawyer would. And this is not to put down employment standards officers and what they do. It is simply that they're operating under specific constraints that have been set up in part by the laws and regulations that creates this approach. But it also emanates out of the fact that they are not there to make big cases and take down employers in the way that lawyers have a tendency to do. Lawyers are out there challenging the system. They're challenging the employer, and they're basing their ability to identify serious problems which do exist with respect to employment situations, and that's what oftentimes they are doing. So without the constraints of the Employment Standards Officer, lawyers pursue stuff more aggressively. So when your former boss or your former boss's lawyer comes back to yourself and says, talk to Employment Standards Officer, find out what their position is on this. They'll let you know how the law works. You really need to take it with a grain of salt, as you do with a lot of other stuff that comes out of your former boss's communications and their lawyer's communications with yourself. Because when it comes to a lot of things as it relates to employment matters, you could create a lot of gray area. And without taking the kind of precision that's necessary and tackling the very specifics and the foundations and legal principles, stuff can be presented to yourself that seems correct, that in certain circumstances may be correct, but has not been effectively and properly analyzed either by your former boss or their lawyers. And that in part emanates from the fact that oftentimes the former boss doesn't really provide all the necessary information to the lawyer, or the lawyer for your boss does not spend all the hours necessary to analyze the specifics of your case. Instead, they're taking the approach that what's been presented is correct, and if you want something more, go get yourself a lawyer. We're not going to tell you where we're wrong. We're not going to tell you where we might be offside. You, as a former employee who's limited resources, needs to get that found out. And what we're going to tell you is stuff in generalities, and we're going to tell you what the position is without getting specifics. We're not even going to look at the specifics. Because if they made a concerted effort to look at the specifics oftentimes, especially what the cases that we deal with, there would be a realization that there are clear errors, clear mistakes that have been done by that employer, and that it is undercutting and undermining the employee's position. And in fact, the calculations that have been presented to the employee are in fact inaccurate. That the amount that's due to them from a legal standard, from a statutory standard, is far greater than what's being offered up right now. But you think your former boss and their lawyers want to just come out and say, oh, well, we actually owe you twice the amount of money that we were willing to pay you. No, that's not what their job is. That's not what they intend to do. If you want to get that answer, if you want to understand it, you need to be talking to somebody who's in your corner. And that means an employment lawyer who understands the law of your jurisdiction, understands the material that's specific to yourself. Because then and only then will you get the correct information, the appropriate information, and you'll be able to pursue stuff correctly and fully. Because like I said, going to an Employment Standards Officer, just picking up the phone and talking to them, and they haven't even looked at the facts, and they got a manual in front of them, and expecting them to give you answers, the spur of the moment, especially when you may not know all the facts that you need to be relaying to them. And that's another problem. If you don't relay all the facts, and they don't ask you all the questions, and you can't provide them with all the answers, how do you expect them to provide you with the correct response? It's very problematic on many fronts. So if you're wanting to deal with these kind of situations, You cannot be relying upon what is stated from your former boss, your former boss's lawyers, and even to some degree, the employment standards officers who are trying to give you insightful information. Your reliance has to be on your own lawyer. You need somebody who's going to delve into the specifics, take the time to look into it, and understand where you need to be coming from to tackle that particular problem. Otherwise, you're not going to get a proper picture as to where you stand, and you won't be doing things in your best interests. And ultimately, that's why people really need to retain knowledgeable legal counsel for themselves, because they need somebody whose only interest is in advancing their own legal and legitimate rights and interests. And when it comes to firings, terminations, layoffs, and the like, in those scenarios, you need to have somebody who is committed to you and committed to getting what you are legally due and entitled to. And that's the role of the lawyer. And that is why you should be relying upon them as opposed to placing your reliance on some other party who is not necessarily committed to yourself or is not capable of committing yourself. And most especially, not upon your former boss and their lawyers. Thank you.